Hello बच्चों, let's see passage 1. It talks about the Supreme Court has held that for the purpose of computing limitation for filing of the appeal under section 61(2) of the Indian Insolvency and Bankruptcy Code 2016, the time taken by the tribunal for providing certified copy of orders to be challenged or to be excluded from the computation of limitation. So basically, when we talk about the Insolvency and Bankruptcy Code, it relates to a person being insolvent or an entity being insolvent. Insolvent in basic terms being when you have liabilities more than assets and you don't have the potential or financial length to pay the liabilities left with you, so you declare yourself as insolvent. So whatever is left with you is taken by the authority to disperse it to the liability owners. Okay, the Supreme Court under section 61 subsection 2 discusses the same. So basically जो tribunal time लेता है certified, आप whenever you have a order for yourself from the court, you will need to have a certified copy of that order if you want to challenge that order of the lower court. So जो certified copies आपको चाहिए होती हैं, उसके लिए court takes a specific amount of nominal fees and a specific amount of time duration in which it has to provide you with the certified copy. So जब आप किसी अपील के लिए जाते हो या फिर यू गो टू अ हायर कोर्ट, देयर इज ऑल्सो अ टाइम बाउंड कि यू हैव टू फाइल एन अपील विद इन 3 years, विद इन 30 days, विद इन 60 days, वट एवर. सो this when Supreme Court held this order, it says that कि जो सर्टिफाइड कॉपीज आपको मिलती हैं ट्राइब्यूनल से, तो वो जो मिलने का टाइम ड्यूरेशन होता है, लेट्स से योर ऑर्डर हैज बीन पास टुडे एंड यू गेट सर्टिफाइड कॉपीज after 7 days, so that 7 days will be excluded for computation of limitation. एक limitation होता है कि अगर आपको 30 days में फाइल करना है तो वो 30 days आपके वो 7th day के बाद से चालू होंगे, because the 7 days loophole was there because the court was unable to give you the certified copy. Okay, Section 61 subsection 2 of the IBC provides a period of 30 days for filing of an appeal against the order of NCLT. The proviso of section 61 subsection 2 of IBC states that NCLAT may allow an appeal beyond 30 days. अब NCLAT क्या है? एक अथॉरिटी होती है NCLT, that is National Company Law Tribunal, एंड नेशनल कंपनी लॉ ट्रिब्यूनल के ऑर्डर से अगर आप अग्राइव्ड हो तो आपको जाना पड़ता है नेशनल कंपनी लॉ अपीलेट ट्रिब्यूनल, दैट इज एनक्लैट. ओके, सो एनक्लैट कैन अलाउ एन अपील बियॉन्ड 30 days. आप एनसीएलटी की हमने पढ़ ली, एनसीएलटी की सिर्फ और सिर्फ 30 days की लिमिटेशन है अगर आपको अपील फाइल करनी है तो, बट एनक्लैट जो है वो आपको 30 days के बियॉन्ड भी दे सकता है, जो कि एक्सटेंड हो सकता है मैक्सिमम ऑफ 15 मोर डेज. तो मतलब 30 + 15 कितना हो गया, टोटल 45 days की एनक्लैट आपको टाइम लिमिट दे सकता है ऑन द डेमोन्स्ट्रेशन ऑफ सफिशिएंट कॉज ऑफ डिले. ओके, उसके लिए आपको ये दिखाना पड़ेगा कि आपको एक्स्ट्रा 15 days क्यों चाहिए, आपको ये डेमोन्स्ट्रेट करना पड़ेगा कि आपके पास सफिशिएंट कॉज था फॉर द डिले. फर्दर सेक्शन 238A of IBC states that Limitation Act 1963 would be applicable as far as may be to appeals before the NCLAT. The NCLAT notified an SOP on 3rd of January 2021 requesting litigants to avail the electronic filing facility through NCLAT e-filing portal. Thereafter, the NCLAT issued a notification on 21st of October 2022 notifying that the period of limitation for filing an appeal would be calculated from the date when an appeal is presented on the filing counter. The requirements of e-filing was directed to be continued along with the mandatory filing of hard copy or of the appeal. So basically उनको e-filing अब with the present order of NCLAT there should be e-filing and hard copy filing both of the appeal. So on 24th of December 2022 a clarification was issued by NCLAT that limitation shall be computed from the date of e-filing of appeal when the mandatory physical copy would have to be submitted within the 7 days of the filing. तो अब फिर से एनक्लैट ने क्लैरिफिकेशन दिया 24th को. उन्होंने बोला कि जो लिमिटेशन है वो सिर्फ ई फाइलिंग की डेट से ही कैलकुलेट की जाएगी, और ई फाइलिंग की डेट के बाद आप जो मैंडेटरी फिजिकल कॉपी की फाइलिंग है वो आप ई फाइलिंग के विदिन 7 days में आप वो सबमिट कर सकते हो. The order clarifies that the requirement of e-filing shall continue with the mandatory physical filing of appeals in terms of Rule 22 of NCLAT Rules 2016. The bench observed that the NCLT order was pronounced on 26th of August 2022. The Rule 3 of the NCLAT rule stipulates that the date of pronouncement of order have to be excluded from computing limitation. तो आपका order जिस दिन पास हुआ है, in this case that is 26th of August, वो डेट को हम एक्सक्लूड करेंगे जब हम लिमिटेशन पीरियड कैलकुलेट कर रहे हैं. दिस इज इन लाइन विद द सेक्शन 12(1) ऑफ द लिमिटेशन एक्ट. तो ये लिमिटेशन एक्ट भी यही सेम चीज बोलता है कि जिस डेट पे ऑर्डर हुआ है उस डेट को हम एक्सक्लूड करेंगे जब हम लिमिटेशन गिन रहे हैं. तो द लिमिटेशन इज ऑफ 45 डेज, जो कि हमने पढ़ा है कि सेक्शन 61 में दिया हुआ है. तो इट शुड बी एक्सक्लूडेड द डेट ऑन विच NCLT pronounced the order. Then a period of only 45 days elapsed on 10/10/2022. Therefore, the NCLAT has erroneously dismissed the appeal on the basis that the same was lodged on the 46th day, whereas the appeal was lodged on 24th day. तो इस present case में यही issue था कि appeal 45 days के beyond गई है, but this paragraph clarifies the appeal was filed on the 45th of the day. According to the bench set aside the NCLAT order, the bench observed that in terms of the Rule 22 2 of the NCLAT Rules 2016, it is mandatory to file the certified copy of the impugned order along with the appeal. In view of the same, the appellant had sent an application to the certified copy for the order to Delhi to NCLT Chennai in 2 September 2022. NCLT Chennai received the application on 5 September 2022, which was within the limitation of 30 days specified under Section 61, subsection 2 of IBC. This established that appellant has exercised due diligence. सो इस पूरे केस में यही था कि क्या अपील बियॉन्ड द लिमिटेशन पीरियड फाइल की गई थी. तो जो बेंच थी उसने ऑब्जर्व किया कि अपीलेंट ने सारी ड्यू डिलिजेंस फॉलो की है. उन्होंने सर्टिफाइड कॉपी के लिए भी अप्लाई कर दिया था विद इन लिमिटेशन पीरियड, और उन्होंने अपील फाइल भी कर दी थी ई फाइलिंग, दैट वाज विद इन द 45 days of limitation period. What does question say? Question number A first says, Mr. Smith received an order from NCLT on 26/8/2022. The order was in favor of his business rival, Mr. Johnson. Distressed by the decision, Mr. Smith decided to file an appeal before the NCLAT within the prescribed time limit. So basically इसमें क्या हुआ था कि NCLT से ऑर्डर आया था. अब ये ऑर्डर कौन सी डेट पे आया था वो दी हुई है. अब वो जो ऑर्डर था वो मिस्टर स्मिथ के अगेंस्ट था. तो मिस्टर स्मिथ ने सोचा कि अब मैं एक अपील डालूंगा NCLAT में जो कि टाइम लिमिट के अंदर होगी. Considering the information provided in the passage, which of the following would be most appropriate for Mr. Smith to ensure compliance with the period under IBC Code 2016. तो हमको ये बताना है कि कौन सा ऑप्शन सबसे सूटेबल है so that Mr. Smith complies with the limitation period given under the Insolvency and Bankruptcy Code. Let's see the option. Option number A says Mr. Smith should calculate the limitation period of 45 days by excluding the date of pronouncement of the NCLT order and the appeal within that period. This is absolutely right option. We have also read this in the passage key for the 45 days of calculation of limitation period, the date on which the order was pronounced will be excluded. So this is right option. Let's see option number B. Mr. Smith should file the appeal within 30 days from the date of the NCLT order as specified under section 61 subsection 2. Section 61 subsection 2 का proviso also gives the additional time period of 15 days as may be given by the NCLT. So this 30-day time period is not inclusive time period, but 45 days is the real time period. So this is a wrong option. Let's see option number C. Mr. Smith should file the appeal within 45 days from the date of NCLT order, considering the clarification issued by the NCLAT regarding the calculation of limitation period. This is a wrong option because after the clarification issued, it was mentioned that the date of the pronouncement of order will not be calculated in the limitation period. Option number D says Mr. Smith should file the appeal within 60 days. The limitation period is not at all of 60 days, and hence this is a wrong option. Let's see question number 2. 2 says Mr. Patel, a businessman, received an unfavorable order from NCLT on 26th of August 2022. He intends to file an appeal before NCLAT to challenge the decision. Based on the information provided in the passage, which of the following should Mr. Patel ensure to compliance with the requirement of filing certified copies of the impugned order along with the appeal? तो अब हमें ये बताना है कि ऑप्शंस में से कौन से ऑप्शन को कंप्लाई करना चाहिए फॉर फाइलिंग ऑफ द सर्टिफाइड कॉपीज. लेट्स सी ऑप्शन नंबर ए. Option number A talks about Mr. Patel should immediately file the appeal before NCLAT without waiting to obtain for the certified copy. This is a wrong option because we have read in the passage that the person who is filing for the appeal must be filed along with the certified copies of the impugned order. So this is a wrong option. Let's see option number B. Mr. Patel should file the appeal within 30 days from the date of the NCLT order and then submit the certified copies to NCLAT at the latest stage. This is also a wrong option. Let's see option number C. Mr. Patel should apply for the certified copy of the NCLT order within the 30 days of limitation period and file the appeal along with the certified copies. This is a right option because we have read in the passage that for filing of the certified copies 30 days limitation period is applicable, and when the certified copies are available, the appeal should be filed along with the certified copies. Option number D says Mr. Patel should file the appeal within 45 days from the date of NCLT order, excluding the time taken by the court to prepare the certified copies. This is also a wrong option because the appeal should be filed with the certified copies. Let's see question number 3. It says Mr. Johnson received an unfavorable order from NCLT. She wants to file an appeal before NCLAT within the prescribed time period. However, due to unforeseen circumstances, she was unable to file appeal within the initial 30 days. Considering the information provided in the passage, what course of action Mr. Johnson take to seek an extension under the limitation period of the IBC 2016? तो हमें इनको ये बताना है कि इनको क्योंकि लेट हो गया लिमिटेशन पीरियड से ज़्यादा, तो ये किस बेसिस पे एक्सटेंशन सीख कर सकते हैं. लेट्स सी द ऑप्शंस. Ms. Johnson should file the appeal within the initial 30 days as specified under section 61 subsection 2 of the IBC without seeking an extension. This is a wrong option because under the section it is specified कि 45 days का time limit होता है अगर आप एक sufficient cause provide करते हैं delay के लिए. So extension तो मिलता है, तो without seeking an extension is not a correct option. Let's see B. It says Ms. Johnson should file the appeal within 45 days from the date of the NCLT order, considering the maximum extension allowed by the proviso. This is a discretionary and she cannot just extend it in her own discretion. It should be proved with a sufficient cause that there was a delay due to so and so reason. So this is a wrong option. Option number C says Ms. Johnson should file the appeal within 45 days date of the NCLT and provide sufficient cause for the delay to the NCLAT to seek an extension. This is absolutely correct option as per section 61 subsection 2 का proviso. Option number D says Ms. Johnson should file the appeal within 60 days. Again, 60 days is not a time limit which we are looking forward to. So this is a wrong option. Let's see question number 4. Mr. Anderson, a businessman, received an unfavorable order from NCLT. He intends to file an appeal before NCLAT to challenge the decision. However, Mr. Anderson resides in different city than the NCLAT and is unsure about the process of obtaining certified copies of the NCLT order. Based on the information provided in the passage, what should Mr. Anderson do to obtain a certified copy of the NCLT order for filing the appeal? बेसिकली क्या है कि जो एंडरसन है वो दूसरे सिटी में रहता है एज कम्पेयर टू जहाँ पे एनक्लैट है. सो वी नीड टू टेल कि सर्टिफाइड कॉपीज फाइल करने के लिए क्या अपील के लिए जो सर्टिफाइड कॉपीज चाहिए होती हैं वो ऑब्टेन करने के लिए क्या करना चाहिए. So let's see the options. A says Mr. Anderson should personally travel to NCLT and request for the certified copy of the order in person. This is a wrong option. उनका वहाँ पे personally present होना is not a mandatory situation. Let's see B. Mr. Anderson should send a representative or lawyer to NCLT to obtain a certified copy of the order on his behalf. This is also a wrong option because requesting of the certified copies in the NCLT can only done through the registered mail जो होता है उससे. So you cannot just send anybody as your lawyer or on your behalf to collect the certified copy. Let's see the option number C. Anderson should request a certified copy of the NCLT order by sending an application to the NCLT through registered mail. This is the correct option. This is through the e-NCLT services. D says Mr. Anderson should request a certified copy of order from the NCLAT instead of NCLT. Again, a wrong option. Let's see the last question, that is question number 5. Mr. Johnson received an unfavorable order from NCLT. He intends to file an appeal before the NCLAT within the prescribed time limit. However, due to unexpected delay in receiving the certified copy of the NCLT order, Mr. Johnson was unable to file the appeal within the initial 30 days period. Considering the information provided in the passage, what action should Mr. Johnson take to address the delay in receiving the certified copy and ensure compliance with the limitation period under the Indian Insolvency and Bankruptcy Code 2016? So basically ये passage ये बोलता है कि जो मिस्टर जॉनसन थे उन्होंने सर्टिफाइड कॉपी के लिए फाइल किया था, लेकिन जब तक एनसीएलटी ने दिया तो जो 30 डेज का अपीलिंग पीरियड होता है इनिशियल वो जा चुका था एनक्लैट का. तो अब उनके पास क्या रिकोर्स है जिसमें वो ये बोल सके कि भाई मेरे को सर्टिफाइड कॉपीज मिलने में देरी हुई, इसीलिए मैं कंप्लाई नहीं कर पाया लिमिटेशन पीरियड जो इनिशियली था. सो लेट्स सी द ऑप्शंस. Option number A says Mr. Johnson should file appeal within the initial 30 days even without the certified copies of the NCLT order. Option number A is the correct option because it says कि आपको अपील फाइल कर देनी चाहिए इनिशियल 30 डेज में ही. इफ देर इज लेट इन द एनसीएलटी का सर्टिफाइड कॉपीज दैट वुड बी कंसिडर्ड बाय द एनक्लैट. सो ऑप्शन नंबर ए इज करेक्ट. लेट्स सी ऑप्शन नंबर बी. मिस्टर जॉनसन शुड फाइल द अपील विद इन 45 days फ्रॉम द डेट ऑफ एनसीएलटी कंसिडरिंग द मैक्सिमम एक्सटेंशन अलाउड बाय द प्रोवाइजो. तो दिस इज अ रॉन्ग ऑप्शन because when we look into the section 61 subsection 2 ka proviso, it says that कि when there is a reasonable cause for the delay. So certified copies, if it is filed before the 30 days also, it can be said that it would be available once it is received from the NCLT. So seeking extension per se for the reason of non-availability of certified copies is not a option. Let's see option number C that talks Mr. Johnson should file the appeal within 30 days from the NCLT requesting an extension from NCLAT providing sufficient cause of receiving the certified copy. This is also a wrong option as we have already discussed in option B. Mr. Johnson should wait until he receives the certified copies of NCLT order filing the appeal irrespective of expiration of 30 days. Again a wrong option. The limitation period has to be complied with while filing the appeal. We cannot go beyond that and just wait for the copies. So I hope the passage was understandable to you. Keep studying and all the very best.